those who haven't seen this before, this is a podcast that's going to talk about the details of appellate court decisions in family law. Many attorneys follow our podcast, and many people that are going through divorces or child custody disputes or any other type of dispute in family court like to follow this podcast because what we do is we break it down. We break down these decisions, and then we try to show how the appellate court decisions that were recently published are going to impact your life. With us today is Mane Hykopian, our senior associate attorney. She is a certified family law specialist, and I might say a very brilliant attorney on top of that. How are you, Mane?
Hi, Don. I'm good. It's good to be back.
Yeah, it's been a long time. And since Mane is our lecturer today, she's going to break it down for us. So, Mane, what are the facts of this case?
Sure. The facts are pretty run-of-the-mill, typical divorce. The parties, Hub and Rod Freeman, were married for over 15 years. And then they're going through a divorce proceeding in Riverside, I believe. And there was some orders made as to spousal support payable by Hub, as well as some property that was divided into divorce, which consists of real property, a rental property that the parties had during the marriage. So on appeal, Hub was challenging the trial court's ruling on, number one, the amount of the spousal support that was ordered, and number two, he was also complaining about the amount of the portion that the court determined was community of this specific property that Hub owned prior to the marriage. And on both of those issues, and he also complained about a third issue of due process, talking about how the trial court didn't allow his attorney enough time to examine witnesses at the last day of trial. And on all three of these issues, the Court of Appeals affirmed the trial court, which means they made the right decision. Nothing's going to change.
Okay. All right. So let's break this case down so that everybody could get a sense as to the particular facts, and they become more tangible, I think, to everybody. So first of all, at the time of their separation, both parties had been unemployed for 7 years, as I understand it.
Correct, yes.
But Hub supported the parties using income from his rental property in Los Angeles, his Social Security, annuities, and dividends. Mm-hmm. And he purchased rental property in 1992. And although the property was titled to him, the parties used the community funds to pay the mortgage, which makes what happen?
The community starts acquiring interest pursuant to the marriage of Moore-Marsden case in the rental property.
Okay. And then the parties stipulated that Hub's gross monthly income was available for support, or that was available for support, was about $11,391. So here they are going through their divorce, and they enter into a stipulation concerning what his monthly income available for support was, which is always a good thing, mm-hmm. right? We want to see if we could reach agreements. You would think that these parties are headed for a beautiful settlement, not having to litigate. But at trial, what happens?
At trial, the court makes various orders as to permanent spousal support payable by Hub to Rod in the sum of, I believe, $2,100. The court awards the community a certain amount for the interest in this property that Hub owned prior to the marriage, and Hub appeals these trial court decisions regarding the spousal support. Hub claimed that the trial court didn't properly analyze the Family Code 4320 factors, and that the amount ordered was greater than the marital standard of living, and that the court also miscalculated the amount of the community's interest in the property.
So why don't we start with that one first? At trial, both parties introduced expert witnesses, which mm-hmm. sometimes we have to do in family court. I think all areas of law, whenever you're litigating, there's a possibility that we're going to be bringing in experts. And family law is no different. We've got all kinds of experts. In this particular case, the experts were appraisers of real property, usually the family residence or mm-hmm. rentals. And from what I understand, Rod had an appraiser, and then Hub provided two expert witnesses,
yep.
right? Now, does the fact that Hub had more than one expert witness mean that he's right and he's going to win?
No, that's what you would think, but it was the exact opposite.
Okay, so what was the rub there between these two expert witnesses? What was the difference between them?
It was quite significant, I would say. So Rod's appraiser valued the property at 2.1 million as of a certain date,
As of February of 2022.
And Hub had two experts. The first expert valued the property at 1.44 million as of January of 2021, and his second expert valued it at 1.6 million as of March of 2022.
Okay, so we have a basic argument that's going on here, and that is when the property should be valued, right? So one of the parties, which is Rod, states that it should be done closest to the date of trial, or actually he's saying closest to the date of trial. So his date is February of 2022. He's saying it should be valued at 2.1 million. Hub, on the other hand, says no, it should be done as of the date of separation, which was January of 2021. Why is that significant in this case, or most cases?
Sure, that's pretty significant because the general rule is that all assets, including real property, are valued at the time closest to trial or settlement for purposes of property division. And I think that Hub had a misunderstanding of the Moore-Marsden formula and when certain things are valued. And so he wanted to use the data separation value because it was much lower. But it looks like his other expert, March 2022, was pretty close to the February date. But I think the court, in the end, the trial court had found Rod's expert to be more credible. So they went with that value.
Okay. And so what I remember for Moore-Marsden is it's a little tricky with respect to how the community acquires an interest and then how much the interest is actually going to be determined to be depending on when the property is valued. And so it's based upon community contributions to the mortgage, and there's a pro tanto interest. So, over many of our cases, there's a combination of increase in both separate and community property, value in the house. And so the community is going to acquire an interest so long as it appraises at a higher value than what it started paying, so long as there wasn't any kind of refinancing or anything like that. But after the date of separation, if the community stops making the payment and the time starts going on, then the community interest could actually decrease in value, right?
Right,
so,
right.
So I think some of this had to do with that, okay? And the trial court then found, I believe, Rod's appraiser more credible and then valued the property at $2.1 million. Now the reason why I think, again, is that Hub knows that he's got to pay Rod some money, even though it's his separate property, the community's acquiring an interest in it. The trial court also adopts Rod's appraiser conclusion that the community owned 60.2% in the rental property.
Right. I don't think they had a disagreement as to that percentage amount, but I think Hub had a misunderstanding regarding what valuation we use for the property to multiply that 60% by.
Now, in all fairness, there are times when the date of separation value of either a business or a house or any asset can be the date of separation. Could you talk a little bit about when it would be appropriate for the court to say, yeah, I'm going to use that value rather than the closest date of trial value?
Sure. A common situation is when one spouse purposely does things post-separation to decrease or devalue, let's say, a business or a home. And at that point, you could make a motion with the court to ask for the court to use an alternate date evaluation, whether that's date of separation or a different time. Another common scenario is with businesses that are what we call personal in nature, where it's run by one person. It's a small mom and pop shop, and you want the business valued closer to the date of separation rather than trial for whatever reason. And there's case law which supports that. That's a common scenario that we see.
Yeah, sabotaging a business is something that happens. I think it happens a lot, quite frankly. The person who is managing the business in a marriage typically is the one that's going to be awarded the business and have to pay half of the value. They don't like that, so they start taking more time off of work. They stop bringing in as many clients. They start loading up the expenses, prepaying expenses, 1 2 years so they don't show a profit. There's all kinds of tricks that they try to do. And, after a close examination, it's possible to bring it to the court's attention and say, hey, look, this has been a purposeful sabotage of the value of the business, so let's use it as of the date of separation. It's a little more tricky with a house, though, I would think. Could you think of any examples where a person, or the type of things that a person would do to be able to justify going back to the date of separation of the value of the house? Because it's not market value, right? I mean, if the house is valued at $3 million as of the date that they separate, they get a divorce, or they're going to trial 2 years later and the market decreases,
Right.
which in Southern California doesn't seem that it happens that often, but it does. And, you got to take the
no
market
one's
for what
fault.
it
Right,
is.
right.
But
I guess if someone purposely trashes the property or does things to decrease the value, I would. But yeah, I haven't seen that too common.
yeah, well, I actually have seen some cases where people you actually have a case, no names mentioned, where the grass is great. It's the other side. The grass is not being mowed, and the things aren't being fixed. There's just general neglect on the property, and so there's a claim at least that hey, we shouldn't go with the current value. And I was thinking the other thing is, what about the opposite? Hey, Judge, this house was valued at $500,000 as of the date of separation, but through my sweat equity and my own money, while this divorce was going on, I paid for a new roof. I added a bunch of things, and I should get some kind of a reimbursement for that. Now, it's a little trickier, right?
That is because if it depends, I guess, if the house started off as separate property or community, because if post-separation you're improving your own separate property, I don't think you would get credit for that.
Yeah.
But if it's a community asset and you're continuing to improve it, not just painting the walls, but putting in a pool or something that's going to greatly increase the value, then I think we're talking about a 2640 right of reimbursement, which I think you would get.
Yeah, of course, it does trigger consent. Did you ask for permission to be able to do these things
That's a good
before you
point.
added that new, game room to the house? No. Okay. Well, why do you expect to get reimbursed for that, sir? Okay. So, what else had happened? You were talking about the spousal support. The trial court, I think you said, ordered Hub to pay Rod $2,100 a month in permanent spousal support. And it applies to 4320 factors, which is Family Code Section 4320. Can you talk about what those are?
Sure. The factors, there's 10 to 12 different factors that go into permanent spousal support, and, it includes things like the marital standard of living, which everybody loves to, talk about. It's just one of many factors. The age and health of the parties, the earning capacity of the parties, whether any of the parties had periods of unemployment to care for children, or whether they advance the other person's career or education or training by, staying home and letting the other person work. Domestic violence is a factor, whether there's a history of documented evidence of any domestic violence. Some other factors, tax consequences, a general balance of hardships. I think those are the main ones that we see. In this case...
Wait. There's one last one.
Which one am I?
Whatever is just and equitable under the circumstances, the catch-all one, right?
The catch-all. So here, they didn't have any kids, but they were married. The duration of the marriage is a big one, 15 years, which is anything over 10 years is a long-term marriage. Rod had, the court found that Rod had stayed home and left his job because Hub asked him to basically go on vacation with him. And so he, at the time of divorce, I think he hadn't worked for 7 years. So although the court said he has an earning capacity, I believe they said he was able to make about $5,700 a month. There was a lot he had to do to get to that point. He was already 60 years old. So those were some of the big factors the court considered. The court also looked at the net spendable income of both parties. And I believe there was an ex-spouse calculation. So this case is recent enough for the court to have used the ex-spouse.
It may be the first published decision, right? I don't know, but it's interesting, yeah.
So one of the chief complaints that Hub had was, the court shouldn't use the ex-spouse for permanent support, which he's correct in arguing that. But the Court of Appeal said that the trial court had, I think it was more than 5 pages discussing the 4320 factors, and it just referenced the ex-spouse, I believe, just for the purpose of showing the net spendable income. So it didn't rely on that. It was just a reference in the overall decision. And so the court found that the trial court did the right analysis and went through the 4320 factors, and that the 2100 was correct. The court was correct in coming to that conclusion.
Okay. So when we talk about the 4320 factors, we're talking about something that a trial court must weigh all those factors when issuing a spousal support order or denying it, right? Either one. By law, it's got to do so. In this case, the court applies the findings that although Rod has marketable skills, his employment was impaired by Hub's request for Rod to take leave under the Family and Medical Leave Act to care for Hub from April to September of, I forget what year that was. Hub further requested that Ron remain unemployed and travel with him, as you indicated, with the income that he built over their 23-year relationship. So this sounds like the typical thing where one spouse stays at home while the other one builds the career and their earning capacity. And, the law states that, well, it's not fair that they don't continue on after that. And then, of course, it attaches the ex-spouse printout to the statement of decision that the court makes here. Now, Hub appeals. He doesn't like the court's orders. And one of the things that he says is that, Judge or the court, Your Honors, he's got more of the income than I do after this order is made. It's not 50-50. That's not fair, right? He's looking at the net spendable income, and he says, hey, Rod works. And when you combine what this court order is with his actual income, he's doing better than I, right?
That happens, yeah.
What does the Court of Appeal say about that?
I think that Hub asserted that Rod is only entitled to, basically he's entitled to half the marital standard of living, and this way he had more, and the court just said that's not really how it's done, and his math was off, and that the marital standard of living is just a general reference point.
It doesn't mean 50-50.
Exactly. It's just a reference point, but the trial court can deviate from that and has wide discretion in making any order for support.
Okay, and given that he weighed the judge weighed the 4320 factors, there was no error in issuing the amount of support that it issued, even if it was more than 50% of the net spendable income between the parties, right?
Right, exactly.
Okay, and then I thought this was really, really interesting, was the ex-spouse calculation of support. You've referenced it already. They attach it to the statement of decision, and here you go. Hub says, wait a minute, you're not supposed to do that because that is actually forbidden. You can't rely on just a calculation like that in issuing support. And the Court of Appeal says, I believe, look, that's not what the court relied on. As you said, we weighed the 4320 factors, and the attachment of the spousal support was just as a reference point with regard to the party's net spendable income.
Right, right.
So, it seems to me that this could be a case that gives the courts really carte blanche in using the computer calculation, right? Nowadays, all you have to do is just, you could attach it, and that's what you're really doing. But then you weigh it's like circular reasoning or reverse, reverse reasoning. You could do the calculation and then say, yeah, now I'm going to support this with 4320 factors.
Yeah, I think that happens a lot.
Yeah.
Yeah.
So interesting. I don't know why they don't just come up with a computer calculation sometimes, and do it. Actually, I'm glad that they do have discretion, though, because there are some circumstances where the calculation doesn't make sense. And you and I know that the courts are allowed to depart from that calculation at any time. It's just a suggestion for temporary orders. And we've seen that before. Either, there should be more or there should be less in some circumstances.
Yep.
Now, getting back, now this is one of the things that I love about the ruling here is Hub contends his due process rights were violated, right? And why does he say that?
He says that because he claims that on the last day of trial, the court had asked, basically both sides were allotted equal time.
They asked for it.
They asked for it, and the court it seems like the trial court was like, okay, you guys have to keep track of this. I'm not going to keep track. And they didn't say anything when the other guy went over his time. And so the trial court, he was complaining, the trial court should have stopped, Rod. I keep mixing up the names. The trial court should have stopped Rod because he used more than his half share. And the court said, there's nothing in the record indicating that you brought this up to the trial court's
You didn't object when it was happening.
Right. You should have kept time yourself. It was up to you, and nothing in the record indicated that you raised this concern, and the trial court made a ruling one way or another. So because it was never raised, it wasn't an issue. And so...
Yeah, I think that folks don't understand that there's limited time in court. And a lot of times when you're trying a case, you got one eye on the clock. It's kind of like you're playing basketball or any other sport, and you're looking at the clock as you're trying to perform, right? And that's what we'd have to do while we're in court, trial attorneys. There's all kinds of tactics that apply. Is getting it to the end of the day, do I really want to stop on my cross-examination, or do I want to slow it down a little bit so I could have a redo, or at the next day that we come into court? Well, this is a case where I've seen many courts say this, and maybe not as much in family court, but say, counsel, you got 15 minutes, or both of you are allotted 2 hours and you're done. And some courts hold you to that. Some courts don't. I mean, I've seen a lot of courts say that they have time limits, but out of respect for the parties, or maybe they want to hear more, they let it go. But I've seen many cases through the years where people say, okay, you're timed up, counsel, or they start giving you a countdown, right? And that is really, really tough. It shows you got to be really organized, I think, going into this. Right. But in this case, they come into there and they say, Judge, we're ready to go. And the judge says, okay, well, I'm going to tell you what. And I don't know if the court said this, but we got an estimated 5 hours, for trial today. That's all I have for you. Okay, so you guys are going to have to divide your time equally. You're going to have to keep time with that.
Yeah, that's exactly what the court told him.
So Rod's attorney is long-winded, right? And he's talking and he's going and nobody's stopping him. And Hub's attorney is kind of like, I don't know, reading his emails or whatever. He's just letting time go by. And what he doesn't do is he doesn't stand up and say, Judge, I have to object right now because he's taking all my time. You said that it was half the time. I mean, what's going on here? Raise the objection.
Right.
Because I think that if you raised the objection, you think the Court of Appeal would have maybe ruled differently?
Definitely. The court noted that nothing in the record indicates the trial court did anything to deny Hub a fair hearing. So if he had raised the issue, perhaps, and the court had denied him, or perhaps the court would have given him another day. You never know.
One thing, I don't want to give away all of our secrets, but one of the things I do is when the other side starts cross-examination, I write down when it starts, and I just keep a track as how much time is spent, because one thing I can't stand is when they get to go on and on and on, and then I get up and I start, and the court starts cutting you off. It's like, wait a minute, you just spent 2.5 hours, right, and stuff. So, it's not a bad idea on your little notepad is to write it down as to when people are talking and what's being said. Cool. So, what do we learn from this hearing today?
We learned that...
From this appellate court decision.
I think the court mainly wanted to clarify. The reason they published this decision was to clarify the Moore Marsden and the misunderstanding that the actual value of the property is closest to the time of trial, but the percentage, to calculate the percentage for the community, you use the data separation. I think that was what the confusion was about. And if you want, I guess one thing I learned is if you want something, you got to ask the court for it. You can't complain about it later, because if you don't raise an issue at the trial level, you can't appeal that and complain about it at the appellate level. And I've actually done a brief on that because it's come up on one of my cases. So if you don't give the trial court the opportunity to make a decision, you can't complain about it later on.
Yeah, this was a really good case for trial skills, right? Learning about, what to say, what kind of positions to take, expert witnesses. I mean, it has a lot to it. So we highly recommend this to folks that are going into family court during trial, so that you could kind of get a feel for what you should be saying and, what you should be paying attention to when there's property and spousal support at issue.
Yeah.
Okay, well,
Good one.
thank you very much, Mane. This was fantastic. Thank you. I hope that you enjoyed this, and we will see you next time on Exhibit A.